young lawyers, especially the issue relating to bails in these economic offences and special law is a very crucial subject, and many youngsters had requested the group and criminal justice group, as you all are aware, that is a group where we learn from sharing each other's experience, right? So I request Mr. Pahwa, without further delay, for on the subject.
Thank you, Mr. Ajay Verma and his team of Criminal Justice Group, who requested me, and I was very excited because we all know we are undergoing very difficult times at the moment. We all are quarantined at home. We have to maintain social distancing. Only essential services are permitted by the government. So since we all are at home, it is important that we do something for the benefit of our colleagues, and we do something to make sure that the criminal justice system continues to work. You all must be knowing that I'm very passionate about criminal law, and during these times I wrote an article. I was not very happy that the criminal justice system has come to a standstill. That was primarily because of those who are languishing in jail. Now, we all know that the conviction rate in our country is very low, which gives an opportunity or an option to majority of people to get acquitted. So anybody who's in jail, we can't presume that he has committed the offense. So they all deserve that their bails should be heard by the courts. And unfortunately, earlier it was not happening, but gradually the courts opened up. And at least now the most essential and the most urgent cases are being heard. Now, why we all, as members of the criminal bar, and also the other members who are working on the civil side, we all have to make sure that the justice system should proceed. Justice system should continue to work. So that at least the urgent matters, not most urgent, but urgent matters are heard by the courts. Now, bail, as we all know, since we are talking primarily on bail, so I'll be focusing more on bail rather than, talking about general stuff. We can do that on any other occasion. Now, bail, as we all know, are dealing with the liberty of an individual who's an accused of an offense. Now, bail means that a person's liberty is controlled by the court by imposing certain conditions, certain restrictions. That if those restrictions are followed, then person can be in liberty. So we all know about that. And you must know that there are some lawyers who specialize in bails. There are various kinds of lawyers who are doing trials, who do cross-examination and argument. There are lawyers in the High Court who argue on the appellate side. We argue writ jurisdiction 482. There are one segment of lawyer who specialize in bails, because bail is a different ball game altogether. Why I'm saying it? Because of my personal experience. I started my practice with my father, who's in Meerut, who's over 80. He's about 85. But even today he practices on the criminal side, but he's not in active practice. He goes to the court for 4-5 hours and then come back. I was with him in 93 and 94. Now, I've seen my father doing 7 to 10 bail applications a day. Imagine 7 to 10 a day means about, if you take 10 as an average, about 50 in a week, 200 in a month, 2,000 in a year, and he did it for more than 50 years. So he must have argued about more than 1 million bail applications. And he was called as King of Bails. And why I'm saying it, I'm sharing this personal information with you because when I was with him, I've seen bails being granted in the most heinous offences. At that point of time, TADA was there, so terrorist activities were on a rise. Still, the judges used to grant bail. I'll give you a small instance. 93, 94, my experience in few bail applications, 3 accused, 3 pistols, One gunshot injury, one deceased. The allegation in FIR is all three came and fired and the deceased died. The court granted bail within 10 days. So there is only one injury, there are three people. How can you say? And you are saying all three fired. So at this stage, we can't say anything, bail granted. Then another allegation, an accused came with a knife and stabbed somebody in the stomach. Postmortem conducted. In the postmortem, there's only a piercing wound rather than an incised wound. The court says, sorry, you are saying knife, it looks to be some other weapon. That means you're not an eyewitness. Bail granted. Can we see this today? In my personal view, in my humble view, no. Because the bail jurisprudence has changed in the last about 20-25 years. It has changed a lot in the economic offences. Earlier, I remember I'm going back in 93, 94, 95, when the traps are conducted by the investigating agency under Prevention of Corruption Act. The trap is conducted, trap formalities are completed, the accused is never arrested. Can you see that situation today? No. In every trap, accused is arrested. He has to be in custody for minimum 60 days and then he is granted bail. So this is the difference in mid-90s and now in 2020. Why? I have my own experience. Since Mr. Verma has given me the opportunity to give my view, I'm giving my view. It may be correct, it may not be correct. But I have seen the bail jurisprudence changing in the last 25 years, so I'll share my view with you on that and then we'll come on to the specifics. Now, the economy was liberalized quite early, say around early 90s. And there were so many finance companies, there were non-banking financial company, the hire purchase of vehicle was on a rise. Every fourth shop in the city used to be a finance company. So government amended the RBI Act. And government also amended the SEBI Act, for instance. So many acts were amended. Now all those acts which were amended, they had an impact on the, they all had an impact on the number of cases. Now when RBI Act was amended, then all these finance companies, they faced a lot of prosecution. Now when the non-banking financial company is facing a prosecution, then the number of investors, a number of people who invested in the finance company rose. So when all these people of finance company, I'm talking about 95, 96, when they were arrested, then the courts were flooded with the people, those who were affected by that crime. And there was not one or two people, there were hundreds of people. So when all those hundreds of people used to come to the court got affected by their presence. So post 95, after the amendment in RBI Act and the SEBI Act, number of cases against NBFC plantation company rose, because of which the bail applications were on a rise. Number of investors started visiting the courtroom. Suddenly, the courts decided that now we have to do the equity. So in a normal 420 case, where accused is released on bail normally in few days or maybe 10-15 days, they started languishing in jail for a longer period of time. That longer period of time is now months, 6 months, 7 months, 10 months, because the court is in a fix. If a bail is granted in these cases, then obviously a lot of people, those who are affected, will create hue and cry. So from there, 95, 96, there was a change in the trend and the bail jurisprudence started changing. Then the real estate projects. The real estate projects, just a second. The real estate project, Mr. Ajay Verma, can you hear me?
Yes.
You can, okay. So these real estate projects, when the economy is liberalized with regard to real estate, then cases were filed against these big power, these business houses who are in the construction business. Again, more number of investors came. This is now, we are in early 2000. Again, the courts are flooded with those investors. So again, the bail jurisprudence changed. Then the 2G case came somewhere in, I think, 2010 and 11. And then came the judgment of Sanjay Chandra. So from 1995 till about 2012, when Sanjay Chandra judgment came, where the Supreme Court reiterated the bail jurisprudence for the first time with regard to people, those who are in custody, we could see that the jurisprudence changed again. So now, post Sanjay Chandra, the law is that if the charge sheet is filed in the case and investigation is concluded, normally the court should grant bail to these accused persons. So they were granted bail. So now we are post Sanjay Chandra. We are now we can witness the change in the jurisprudence. 77, Justice Krishna Iyer said that bail is a rule and jail is an exception. Some people followed in the beginning, not. 95, economic offences undergo a change. Many investors came, so they were the change. And now Sanjay Chandra is the law on bail as far as regular bails are concerned. Now coming to the point in issue today. Point in issue is Mr. Verma was very keen that we should address the issue of special acts. Now, under normal case of 420, 406, 409, Sanjay Chandra prevails, which says investigation conducted, you are not required, so therefore accused is granted bail. But in special acts, now what are special acts? Special acts are enacted or passed by the parliament to deal with a specific problem. Now what are those specific problems? So when the government wanted to deal with corrupt people, they enacted Prevention of Corruption Act in 1940 and then in 1988. 40 was repealed and 1988 came the act. So when a special act is passed by the parliament to deal with a particular problem, then those special acts which are code in itself, they to deal with that core issue, the new procedure comes in that special act. The new procedure is the trial should be concluded within a shortest period of time, bail should be restricted, the challenge to orders should also be restricted, so revision should not be filed, 482 should not be filed. All those provisions of law are created in those special acts. Now in most of the special acts, like we can deal with Prevention of Corruption Act, or with regard to terrorism, we had TADA, Terrorist and Disruptive Activities Act. It had a procedure which was totally different. Then we have MACOCA, Maharashtra Control of Organized Crimes Act. Again, there's a different code which is given because they're dealing with a particular problem. So, and then there is Scheduled Caste, Scheduled Tribe Act. Now, with regard to economic offences, we have either MACOCA, or we have Prevention of Corruption Act, or we have Money Laundering Act now, which probably is the law which will prevail in future because it has very, very wide ramifications. And then we have a new investigating agency called SFIO, Serious Fraud Investigation Office. Now, SFIO has been introduced in the Companies Act. The Companies Act 1956 was repealed, and 2013 Companies Act, the new act was introduced, and Chapter 14 deals with the powers of SFIO. Now, I have two things to say for all the lawyers who are interested in practicing on the criminal side. Pick up money laundering, that has a great future. Pick up SFIO, that has a great future, because those are going to stay and they are very stringent and they have very, very wide ramifications. Now, if we start with money laundering. Now, money laundering, again, there was an embargo on bail, right? And that embargo on bail is Section 45. Section 45 says that the court can grant bail to an accused in case of money laundering only when the court is satisfied that there are reasonable grounds of believing that the accused is not guilty of that offense. And if released on bail, he will not commit the same offense. Now, these are twin conditions which are in almost all the special acts. NDPS, Section 37, and we have Unlawful Activities Act, there is a embargo on bail. Then we have MACOCA, similar twin conditions, and SFIO again under Section 212, subsection 6, I think, there's again an embargo on bail. Now, these are special acts where special provisions are created, and most of them have a restriction on bail. According to the government, they can classify an offender or an offense in one category and deal with that separately. Now, if we concentrate on 45, now 45 has a history. 45, now if you see this rigors of 45, the act came in 2005, Prevention of Money Laundering Act, which came in 2000. It is 2002, but it started coming up only in 2005. 2009, a lot of cases were filed in money laundering. So from 2009 till about 2017, about 8 years, the bails were very, very difficult in this provision, in this act. Why? Because the constitutional validity of Section 45 was under challenge, and it's only in 2017, November in 2017, that the Supreme Court declared Section 45 as unconstitutional. So my first recommendation, in fact second, first was Sanjay Chandra. I want all lawyers, those who are not practicing on the criminal side but want to pick up the criminal law and particularly bail, should read that judgment. You can also read Justice Krishna Iyer's judgment, Guddi Kanti, 1978, and there are many of them in between. But Justice Krishna Iyer's judgment, important. Sanjay Chandra, important because Sanjay Chandra deals with all the law. And now we come on to the most fabulous judgment of Nikesh Charachand Shah. This is a judgment passed by Justice Rohington Nariman, and it's a beautiful reading because Justice Nariman, since he had always practiced in the Constitutional Court, so understands Article 14 and 21 better than any other judge. And he has gone back to Magna Carta. Magna Carta, this I think chapter 39 came in 1215. So he's discussed Magna Carta, that even in 1215 there was a provision which deals with the liberty of an individual. So 1215, now we are in 2017. He started from there and ultimately he declared Section 45 as unconstitutional. Now the problem is, as I told you, bails were easier pre-1995, difficult post-1995, particularly in money laundering cases, till this judgment came in November 2017. The bails were extremely difficult. So we have done so many cases pertaining to money laundering, and it was so difficult for us to satisfy the court that at the stage of bail, at the stage of investigation, at the stage of arguments on charge, etc., we can't satisfy you that there is no reasonable ground to believe that accused is not guilty of that offense. How can you? That amounts to giving an acquittal. So just imagine the twin conditions which are interpreted by the court, saying that you only grant bail when you are satisfied that he's not guilty of offense. So what kind of language is this? If the court is of the view that he's not guilty of the offense, the court might as well acquit the accused at that point of time. So this test is very, very difficult test. But somehow in many acts it has stayed. In NDPS Act it's there, Makoka it's there, unlawful activity is there. But Justice Rohington Nariman has very beautifully discussed that under what circumstances this kind of twin conditions can be imposed, and this money laundering is not such an heinous offense where it should be imposed. And fortunately or unfortunately, the language which was used by the Parliament at that point of time was very different than the language which was proposed in the bill. So the language which was given in the Act in 2005 was that you only grant bail when the judge has reasonable grounds of believing that he is not guilty of a scheduled offense in Schedule A. So the Honorable Supreme Court says, how can you say he's seeking bail in money laundering? You want the judge to satisfy with regard to an offense which is a scheduled offense, which is like quite preposterous. So on those grounds, so once you read that judgment carefully, you will understand how the constitutional, how the Constitution is interpreted with regard to classification of an offense. So the Honorable Judge has dealt with all the provisions. Now post this judgment, the moment this judgment is passed in November, unlimited number of people got bail. So what we want, what we have seen in our country is that whenever there's a complicated provision of law or an act which is passed, ultimately we have to wait for the Honorable Supreme Court to intervene. So when Honorable Supreme Court intervenes, deals with the provision, only then the law is settled. Under Article 141, then it has to be accepted by everybody. Fortunately, in PMLA, the Honorable Supreme Court could do it. In SFIO, where there is a similar analogous provision, which is paramateria to this, is still there. And SFIO is dealing with violations under the Companies Act, where again we see people are languishing in jail for months together. Now the offences which are there are very, very, according to me, not as heinous as they are in the case of Tada or in the case of Makoka or in the case of any other provision of law. So therefore, in this case, in SFIO, the bails are not being granted. In SFIO, Mr. Burma, I have a problem in the screen. Now I'm back on this, yeah. So in SFIO, the bails are very, very difficult because the courts are required to unmute. The courts are required to fulfill Section 212(6) of the Companies Act. So in special acts, bails are difficult because the court has to satisfy those twin conditions. Now the fourth judgment, which I want everybody else to note down, is what is the test of satisfying those twin conditions. There are not many judgments. So there is one judgment in Makoka, which is Ranjit Singh Brahmjit Singh versus State of Maharashtra. This is 2005, Volume 5, SCC 294. Now this judgment is a judgment where the accused was the Commissioner of Police of Maharashtra. There was an allegation against him that he conspired in a case where Makoka was imposed, and the case ultimately reached the Supreme Court. And Supreme Court says in this judgment that the court has to maintain the delicate balance. The idea is not to come to a conclusion whether he is guilty of an offence or not. That test is only for the purpose of grant of bail. So you have to have a prima facie satisfaction. If you feel prima facie that there are grounds for believing that he can be, he cannot be guilty of that offence, then bail can be granted. So this is a good judgment to read with regard to the jurisdiction of the imposition of twin conditions. Now, if you see with regard to special acts, many other important proposition of law which come. Now, one of the proposition of law is that in, for instance, take SFIO cases. In SFIO, in every complaint which SFIO is filing today, the number of accused are in hundreds. I'm doing a case from UP where there are 188 accused. I'm doing a case in Delhi, again from Delhi, where there are 300 accused. Now, the proposition is that if the accused is not arrested during the course of investigation, and only few of them are arrested, the complaints are filed, what will be the fate of those people who are not arrested, but they are nominated in the charge sheet and they have to come and face the trial? Will they also have to satisfy the test because they are never, arrested? So again, these are questions of law which are at very nascent stage. Some judges say no, since they are not arrested. There are two judgments from Punjab Haryana High Court which says that sorry, if the investigating agency is not arrested during the investigation, why should they satisfy this test? Because they have chosen not to arrest these accused persons. Again, it has not reached Supreme Court, but there are some conflicting judgments. Some judges agree, some judges do not agree. Now here our role comes as criminal lawyers. We have to help in the growth of law. We have to help in facilitating the courts to give justice, to interpret the law in the right manner. And I firmly believe that the view given by Punjab Haryana High Court is the right view. And if the investigating agency has not arrested the accused person, then bail should be granted to these guys. Whenever they come to the court, because the cognizance has to be taken, summons have to be issued. When summons are issued, they appear in the court. They have complied with the summons. They are appearing in the court, so bail should be granted to them. But again, it's an area where we don't have a judgment of the Supreme Court. Another very, very important aspect is that after 45 has been declared as unconstitutional by the courts. Now, if the dates are very important. I think I have noted down the dates somewhere. Now, it was declared unconstitutional on 23rd 11 2017. Now, immediately thereafter, the government amended the section. The date of amendment is 19th April 18. After 5 months, they amended. And the government's view is, sorry, the Supreme Court had a problem with the language of section 45. Supreme Court said there can't be any satisfaction of the scheduled offence. Now we are saying the satisfaction is of under this act. So once it is amended, can 45 be applicable now, and the bails can be restricted and these stringent conditions can be imposed? So the question came before many high courts, and 2 or 3 high courts have already said no. Once it is declared unconstitutional, it is declared unconstitutional. The parliament cannot amend the section, change the language of the section and try to bring it back from the back doors. So there are again 2-3 judgments, one from Bombay, one from Delhi, one from Andhra Pradesh, which says, sorry, even today, this 45 cannot be read. 45 has been declared unconstitutional. So what is the net effect? Net effect is that in PMLA, if 45 is not there, then it becomes a normal offence. Then it becomes just any other offence. Then the provisions of CRPC will be applicable. Then from section 437, 438, 439 will be applicable, and bails can be granted if the conditions in those sections are satisfied. Another argument which comes under special laws, that whether 438 will be applicable or not. In some statutes, the provision of anticipatory bail was prohibited. Now I remember doing Tada cases, there was no provision of anticipatory bail in Tada. There is no provision of anticipatory bail in Unlawful Activities Act. So there you can't file anticipatory bail at all. It is prohibited under the statute. But it is not prohibited in PMLA, it is not prohibited in SFIO, in the Companies Act. So in all those cases, the anticipatory bails can be filed. Now the proposition of law is whether those twin conditions have to be satisfied when anticipatory bail is being argued. Again, a grey area as of now. There are not many judgments. But anticipatory bails are being filed, they are being entertained. If you are able to satisfy the court prima facie that it's a good case for bail, the allegations are not very serious, they are being entertained, and the bails are being granted. But again, very, very few judges are granting bail, anticipatory bail in these special offences. Now, it is important for all of you to also read the proviso in the prohibition. Now, in all these cases, the proviso says that the accused who's less than 16, woman or sick and infirm, they have to be treated as an exception. So if you fall into that category, you can always argue and say that those twin conditions are not applicable to me because I fall into that proviso. So the proviso is there to help people, those who are in that category. But for instance, medical bail. So if somebody isn't sick, so the lawyer can take advantage of the proviso and say that twin condition will not be applicable because he's a sick person. So these are the important aspects. I don't mind, this is the general idea which I can give, but of course, criminal law has, it has its own nuances. The beauty about law is you put one set of facts in one provision of law and it reacts differently. Every time it will react differently. So we have to rely on the facts to interpret the law. Mr. Verma, in case you want people to ask questions, then I can answer them. Or if you want me to continue.
Before I go on that aspect, Mr. Pahwa, I would like also to request you,
yes,
in case if you can emphasize on your experience in handling with the SFIO cases, because
yes,
that is also a corporate crime involving the Companies Act, and then what are the arrest powers, and then how the client's access is given and how we can immediately approach to the bail.
Yes. Uh, Again, this is my personal view. Now, SFIO cases, we all know that SFIO officers are basically bureaucrats. They are not, from the police. Of course, they're intelligent. They have the knowledge. They have the legal acumen also. But what I see is that in all these SFIO cases, the trend is that uh, anybody who has touched the facts, anybody who's connected with the fact, whether there is any mens rea or not, whether there is a criminal intent or not, he is implicated as an accused. So every SFIO case, as I mentioned earlier, the number of accused are much more. Number of accused are in hundreds. Now, according to my experience, I have seen 4 or 5 cases as of now. Now, the SFIO arrest very few of the people. Now, SFIO has the power of arrest under 212 subsection 8. Now, in 212.8, if you see the language, the test for arresting an accused person is much higher. Now, power of arrest under CRPC is merely on a suspicion. If you see, read section 41. But when we read these special acts, the power of arrest is on a very high pedestal. Now, let me read section 212 8 for you. If you see 8, then it says the director, additional director, assistant director of serious fraud investigation office authorized in this behalf by the central government by general or special order has, on the basis of material in his possession, reason to believe, the reason for such belief to be recorded in writing, that any person has been guilty of any offense. Language is not that he might have committed the offense, or there is a suspicion, reasonable suspicion that he has committed the offense. The test for arrest in SFIO cases only when the SFIO official is of the view that the person has been guilty of any offense punishable under section this. Same is with, I think, money laundering. Money laundering, section 19 is the power of arrest, which again says that any person has been guilty of any offense punishable under this act. So the parliament is conscious of the fact, legislature is conscious of the fact that we are giving powers to these officials only when the investigation reaches that level where you know that he is guilty. But still, arrests are made mainly on suspicion. Arrests are made at a very, very initial stage. How can at a very initial stage the SFI official can come to a conclusion that he is guilty unless and until comprehensive investigation is conducted? But it is done. If it is done, then we have to fight that battle. We apply for bail. First of all, challenge the custody. Very often the custody is granted. Just take it that it will be granted. So what we can do is minimize the number of days. So we argue for that. Then we argue for bail. And courts very often say the investigation is at a very nascent stage. We try to convince the court that, sorry, the power says that I can only be arrested if I am guilty of an offense. In 4 days of investigation, how can the IU comes to the conclusion that I am guilty? He has to conduct very comprehensive investigation. Anyway, he is taken into custody, then charge sheets are filed, or complaints are filed for that matter, and then we argue on bail. So in SFIO, the matter is also in the Supreme Court, where the power of arrest is challenged, procedure is challenged. I think Justice Dr. Muralidhar passed some orders which were challenged in the Supreme Court. Those orders were set aside. Justice Muralidhar said, please tell me, how do you conduct investigation? How does Ministry of Corporate Affairs maintains the case diary? Whether you are following CRPC or not. At that point of time, because it was very, very early, they could not satisfy the court. The proceedings were quashed and bails were granted. Matters in Supreme Court. It is still pending. So we are again facing the same issue that those twin conditions have to be satisfied, and those twin conditions are in some cases we are able to do it. I think we filed anticipatory bail after the charge sheet was filed. People were not arrested. Justice Gauba passed many orders for us and referred us back to the trial court. So and in many cases, I think Justice Anu Malhotra recently in 2 cases granted us bail, even after charge sheet is filed, saying that they were not arrested and going into the merits and satisfying prima facie that it's a case where bail should be granted. So, Mr. Verma, as far as SFIO cases are concerned, there are very few. But yes, twin conditions have to be followed because they are there. They have not been declared unconstitutional. So, we have to file bail. We have to satisfy the court.
Yeah, before I go on the questions, there are so many questions have been asked by the participants. But some of them has asked that, could you please throw your light on some bail under GSTs? Because that is also these days have been used for arrest the
Yes.
corporate directors.
Yes. GST again. I think recently argued few cases of GST. I don't have the act with me, but GST again. The arrest, the biggest problem which all of us are facing, and which we have to take it again to the highest level, is there are some judgments with regard to which tax was there earlier. I think there is a judgment which is passed by Delhi High Court by Justice Muralidhar and Justice Bhakru, which has reached the Supreme Court, and Supreme Court has approved it. Now, the biggest argument which I would like to request everyone to analyze is that in GST cases, you arrest only when the adjudication proceeding or assessment proceedings are over. Now, what they are doing is the GST officials are arresting the accused person right at the very threshold without even analyzing or assessing what is the liability of that particular company. Now, once an accused is arrested, he is brought before the court. Again, the argument is, are you paying the tax? If you pay the tax, you get bail. If you don't pay the tax, then you languish in jail. So all lawyers want that their clients should be released at the earliest. So very often I have seen the lawyers go and make a statement, yes, we are ready to pay the tax. We are ready to pay the tax, give us some time. So time is given, time frame is fixed, and the bails are granted. I don't agree with this concept. My concept is that till the adjudication proceedings are initiated, till show cause notice is issued, assessment proceedings are initiated, a reply is taken from the party, and it is assessed. It is assessed that yes, this is the liability, now you have to pay. Till then, arrest should not happen. But arrest is happening contrary to this procedure. There is the judgment of Justice Muralidhar which says that you can't arrest till the inquiry is conducted. And that judgment was upheld by, that was in service tax, not in GST. But that was in service tax, but the provisions of law are the same. The procedure is the same. In fact, the language is exactly the same. So and that judgment has been accepted by many high courts. And all those high courts says that yes, first you assess, first you conduct an inquiry, because that inquiry period is about 3 months' time. So nobody wants to wait. The GST department doesn't want to wait. So GST department hurriedly arrest an individual so that they can recover the tax. So please read that judgment. It is, I think, makemytrip.com versus Union of India.
Thank you, Mr. Pahwa. For one thing, I wanted to inform here that a couple of persons' video I might have disabled. I have my apologies because I want this session to be nicely streamed to all of you. There is a question which has been asked by one of the participants. It seems to be very important, that is reverse burden on the accused contained in twin conditions under Section 2126 of Companies Act, arrested under 2128 after the investigation is completed against right to silence under Article 19(1)(a) and 20.
Hello?
Does this violate the right?
Yes.
Right to silence?
Yeah. I can answer that. So the simple explanation for that is that if we go by the Indian Penal Code, the onus of proof is always, the burden of proof is always on the state, except for few offences like this abetment to suicide, dowry death. If certain things are satisfied, then the burden goes on to the accused. Accused has to come and explain. So the normal principle is, it is the state which has to prove its case. Now, as I told you earlier, that government has the power to classify a particular offender, constitute or pass an act only for that purpose, for that objective, which they have satisfied everyone in the parliament. They can constitute their own procedure where they reverse the burden. Now, if you see, I can start with Prevention of Corruption Act, for instance. Prevention of Corruption Act, Section 20 says the burden of proof is on the accused. Now the law is very clear on that. The law is burden will change only when the foundational facts of the case are established prima facie by the prosecution. So whenever that situation comes, we always argue in the court, sorry, you can't ask me at this stage to give my explanation because they have to first satisfy whether the foundational facts are proved or not. So burden of proof, the situation comes only in the trial when the foundational facts are established. If foundational facts are established, like in a case of Prevention of Corruption Act, if it's a case of trap, the initial trap is established, initial demand is established, subsequent demand during the trap proceeding is established, acceptance is established by way of hand wash, then the onus comes on to the accused to explain how the money is found in his possession. Same logic will be applicable in money laundering. Same logic will be applicable in many other cases where the burden of proof reverses. So I remember arguing, I don't want to nominate the bail which I was arguing, and I was asked the question directly by the court in the High Court. The High Court says it's a case of demonetization. So High Court asked me, explain, while I'm arguing the bail application, explain, how did you get this money? I told the court, I said, how can I give you that answer at this stage? We are at a stage where even the charge sheet has not been filed. You are asking me to file an affidavit and explain it to you. Then the court says, sorry, the onus is on you. I tried to explain it to the court, sorry, onus is not on me at this stage. Onus on me will be at the stage when the trial is going on. At this stage, they have to establish their case. This is like a normal case. So burden will shift only when the trial is being conducted, not at this stage, because it will be violative of Article 20, Clause 3, I have a right of silence. Just like, Section 91, during investigation, Section 91 notices are issued to the accused. They are told, please give us these documents, answer these queries. How can it be done? The accused has a right of silence. Article 20, Clause 3 says no person can be put to jeopardy who's accused of an offense. He has a right of silence. So, but very often these things happen. But as far as coming back on this question is concerned, that burden of proof on accused comes only when foundational facts are established.
There is another query which has been asked by one of the participants, saying the statement recorded by the SFIO.
Yes.
Unless not retracted, what is the implication of on the bails?
All these, what happens is that these investigating agencies, they used to do it in Customs Act. Before they arrest an individual, they call the accused. Because the accused is not arrested, he is under examination. His statements are taken, and those statements are taken when he is not in custody. So they will not hit by Section 25 of the Evidence Act. So all those statements, in SFI also they have the power to get the statement recorded. In money laundering also they record. So all those statements, according to the law at the moment, has a relevance, and those are always, they are always considered even at the stage of bail. Whenever you argue a bail, the prosecutor will start reading those statements, and we always tell the court, sorry, you don't read these statements. These are my own statements. How can you read it against me? But yes, statement again of the witnesses can be looked into even at the stage of bail. But those are, when the bail is being considered prior to filing of charge sheet, it's a confidential document. They will not share it with us. They will say that investigation is pending. Sorry, we can't share it with you. And we can, give it to the court. Just like this, envelope business started recently. In considering the bail, the investigating agency used to, forward a sealed envelope to the court that this is a confidential document. We can't show it to you. These are statements recorded of witnesses, which we can't show it to the accused. But the Supreme Court says, sorry, we will not look into it unless and until copies are given to the accused or to the applicant who's in the court. So these statements are read, of course, even at the stage of bail they are read, but most of the time they are not shared with the accused.
there is another query which has been asked, which the participant is asking.
Yes.
So at the time of argument of bail, and the arguments are raised that there is a prima facie the offence is not committed, and at that stage the defence discloses the major defence, and will it not give the opportunity to the prosecution to improve their case?
Well, of course, these are basically offences which are based on documentary evidence. So the theory of defence being not disclosed it's a big debate. But you will always see a conventional criminal lawyer will always guide his juniors and colleagues that don't disclose your defence. Don't draft very lengthy bail applications. Those were the stand when the cases were purely on oral evidence, like a case of murder or a robbery, where but these are cases which are based on documents. Sometimes you need to disclose your defense because you need to explain the document. Suppose there is a balance sheet which is misconstrued by the investigating agency. So you have to come up at the stage and tell the court, sorry, my balance sheet shows this. The notes in the balance sheet are not being appreciated. Notes give the explanation. So notes are not appreciated. Notes to the accounts, which are part of the balance sheet. So they will not show the notes, they will place the balance sheet. So I don't think we can strictly today say that you can't disclose your defense. Sometimes it is imperative. It all depends on the facts and circumstances of the case. Since it's a case of documentary evidence, you can't hide that documentary evidence. That will come to the court in any case. And now these are all public documents. In SFIU investigation, majority of documents are, with the ministry, with the ROC. So you need to give an explanation. You need to bring your chartered accountant in the court who can explain the documents better than the chartered accountant of the SFIU. So I don't think there is a big issue with regard to disclosing your defense in economic offences.
The another query which has been asked by one of the participants is
yes.
Your view on the eventual PC Act Amendment 2018, and there is no saving clause. So what happens to the trials for which the accused is charged, and that offence is no longer an offence under the new Act?
Ajay, we are going out of our brief now.
Yeah, I think let's.
But I can still answer. Let me answer that. Let me answer. I will not take too long, because again, this is very close to my heart. I am arguing this in the High Court. So my personal view is, and depending on what others feel, my view is also based on the judgments of Supreme Court and law on amendment, law on substitution of the offence, and law on saving clauses. Now, if you see the amendment in Prevention of Corruption Act 1988 in 2018, it has changed the tone and tenor of the offences. Take for instance section 13. Now, major prosecution prior to 2018 in the new act, in 1988 act, was in section 13(1)(d), right? And in 13(1)(d), Roman 3, the law was that if the public servant has acted contrary to public interest, now he may not have a dishonest intention. Suppose there is a secretary to the government of India, he takes a call, takes a decision which is contrary to public interest, although he doesn't have a criminal intent, he is not cheating anyone, he is not making any money out of this deal, still he can be prosecuted. So when 13(1)(d) Roman 3 was being interpreted like this, the matter was taken to the Parliament. There were few judgments passed by the court, which are still pending in the Supreme Court. Then the committee, the parliamentary committee, sat and decided and wanted to amend the Prevention of Corruption Act. So they consciously amended the Prevention of Corruption Act, particularly this offence, saying that public servant will be an accused in this case only and only when he is deriving a benefit out of his action. So he is abusing his position, he is abusing his official position to gain some benefit. Like a case of misappropriation. The power is given to the public servant, he is misusing because the power is given to him, and it has resulted into benefit to him. So this is consciously done. When this is consciously done, then the old section 13(1)(b), Roman 1, 2, 3 have not been saved in the saving clause. Now the earlier amendments have all been saved. In this case, they have deliberately not saved. Means that once it has to be treated as if this offence never existed on the statute book. That is the interpretation. Otherwise, the Parliament should have saved. Parliament would have said, yes, till 18 this was an offence, and all the trials which are pending, all the investigation which are pending should continue. So we are saving this offence. Like section 30 and 31 in the end of the Act saves the 1940 Act. Prosecution in 1940 Act are still continuing because there was a saving clause. Section 165 of IPC with regard to the offence which was just like the Offence of Prevention of Corruption Act, that is also saved. But why this is not saved? Because the Parliament never wanted that it should be saved. So my interpretation is that all those offences, all those trials which are pending with regard to 13(1)(d) cannot continue today because of the fact that this will be treated as if 13(1)(d) never existed on the statute book. So all those trials should be over irrespective, because that is the effect of law of the amendment. Now the courts cannot say that sorry, there are hundreds of trials, people will be discharged. Let them be discharged because this is not an offence. But it is still pending in the court. We are arguing in the High Court, it's pending. So we can have a session purely on this, Ajay, whenever you want.
Thank you, Mr. Pahwa.
Yeah.
I understand. There are many queries, participants. I would like to inform you that since this session is limited to the economic offences crime, and on general bails and other aspects, on charge sheets and trials, we can have another sessions separately for that.
Yeah.
This, I think the last question which I would like Mr. Pahwa to float to you is that many of the persons are asking that a bail is granted under the Act, special acts, and then tomorrow the agency goes for cancellation that this person is not cooperating and giving his statement and cooperating with the investigation. Can that be ground for challenging the bail granted already?
Again, the proposition is that bails one granted can be cancelled. This is one stage. That if the bail is granted to an accused, and accused is misusing the liberty granted to him. Suppose during the course of investigation he is released on bail, and when he is called by the investigating agency, he doesn't cooperate, or he tampers with the evidence, or he tries to threaten the witnesses, then bail can be cancelled, just like any other case. Now what has happened, but what's happening in these cases is that instead of seeking cancellation, the bail orders are challenged nowadays. And on a drop of a hat, in every case, you take a bail from the special judge, invariably that order will be challenged in the High Court. So earlier the law was that once bail is granted by the concerned court, then it can only be challenged if it is being misused. But now in 482, the orders are challenged in the High Court on merit. The argument of the prosecution is that the trial court should not have granted bail under these peculiar facts and circumstances. So 482 power is used along with 439, and the orders are challenged. You will be surprised, even medical bails are challenged. It is so shocking. A person who's granted medical bail in these special acts, and we have seen that the order is challenged in the High Court. So it can be challenged, provided it comes within those guidelines. Supreme Court has issued guidelines with regard to cancellation. There are many judgments, and in all those judgments, Supreme Court has laid down, if you tamper with evidence and all those grounds, the bail can be cancelled. Yes, just like any other IPC offence.
Thank you, Mr. Pahwa, on this. One of the last question I think we would be bothering you is during this pandemic situation.
Yes.
And the courts are very reluctant in granting bail to the accused in the special economic offences, whereas the chances of remembering with the evidence and other things, threatening with the witnesses, are very less. And because all the cases are depending on the documentary evidence, most of the time balance sheets and the auditor reports and other aspects. So what is your view, why the courts are reluctant in granting these reliefs to the the persons accused of these cases. During
Mr.
this
Verma,
inspection
if you have seen the minutes which are issued by the high-powered committee, in the beginning they had relaxed all the offences which are up to 7 years, which includes 420, 406, etc. And even in the case of forgery, they said everybody will get bail, and they'll get interim bail. Later on, this was improvised, and they had relaxed it further, included the offence which are punishable up to 10 years. But in both these minutes, I think first was 23rd of March and second was somewhere in April, early April. In both these minutes of meetings, they have excluded the special acts. They have excluded SFIO, they have excluded money laundering cases, they have excluded Prevention of Corruption Act cases. So it is a policy decision which they have taken. I don't know why they feel that these are special acts, these are more heinous because they deal with a particular class of offender. So in their own wisdom, they have decided not to entertain their bail application. And today, no bail application on merit is being considered by any court in the country, which I think is wrong. My personal view, as you know, it's very public now. My personal view is that the court should start functioning through digital technology, not normal courts, but the criminal justice system should continue to function. Bail application, even on merit, should be entertained through video conferencing. I mean, how many, it all depends. If you upgrade the technology, you may have 100 to 100 cases in a day. Today, they are maybe hearing about 10 cases a day. So from 10 cases, we have to take it to 200. That should be the objective of our judicial system. That should be the objective of the courts. So my personal view is that why should somebody who is languishing in jail, who may be acquitted tomorrow, continue to stay in jail just because there is a pandemic, just because we can't deal with this situation. So I feel just like police, just like doctors, just like health workers, just like people who are with the municipality, just like chemists, they all are performing their duties. So we as lawyers, we as judges have to rise to the occasion, create a system and upgrade the system so that maximum number of people get justice. So we should, get rid of this extremely urgent, quote unquote, the category. We can bring at least the urgent cases. And urgent cases are that old people, those who are senior citizen, ladies, and children who are in jail, they can be released on merits.
Thank you, Mr. Pahwa. And I think at this moment, I would like to share a couple of points with all of you that when this 23rd March order was passed by the Supreme Court of India for decongestion of prison, the Delhi population of prison was 17,000 and almost now it is 15,000. So 2,000 people have been released. And as Mr. Pahwa said, the High Powered Committee on 28th of March as well as 7th April has recommended release of people. Now they have extended the scope of those who are above 60 years, if they are in more than 6 months in jail for an offence punishable up to 10 years, they are being granted interim bail. Those who are less than 60 years and if they are in jail for 1 year, they are being granted interim bail. But all these persons, those who Mr. Pahwa has suggested that these special offences, SFIO, PMLA and other CBI related offences, they are not getting that relief. And especially even for the medical bail also, they are supposed to go to courts. And at this moment, the hearing of court in emergent cases is being declined most of the times, and many lawyers are approaching. And this is the time when current pandemic situation is happening, and I think we all will get hearing quickly all those matters. And here, since this time, we started using technology, and I think this is the first time when I requested Mr. Pahwa for this criminal justice group. We all believe that learning by sharing is always enriches our knowledge. And I have many of the colleagues, and my apologies that many questions I might not have asked to Mr. Pahwa because of paucity of time. But at this moment, I would like to thank the few organizations, the IBJ India, for providing this technology. And I'm thankful. Could not not join because we had limitation of 300 people on this call, and I think I will be sharing the recorded video with every one of you, whosoever is requesting. Thank you, Mr. Pahwa, for sharing your time.
Thank you, Ajay. I would like to say one thing. Ajay, I would like to say only one thing to all my friends who have joined us today. That in these difficult times, when we all are quarantined at home, where we have to maintain social distancing, we have to follow the guidelines which are issued by the government in its true letter and spirit. But this is the time to introspect. This is the time where we must sit and analyze what exactly we have done in our lives, whether we have done the right things or wrong things, whether we deal with the nature in the right perspective, whether the people who come and serve us on daily basis. Now we see the importance of everybody who's around us. People, those who spend years with us, this is the time to introspect. This is the time we must sit down and see that life should be simple. We should be more humble. We should have compassion. All these things come naturally to a human being. And as far as criminal justice system is concerned, we must elevate it to the next level. We must get conversant with the technology. We must tell the courts that you have to upgrade the system. We have to put pressure on the government that funds are given to the courts so that they uplift the system. They can upgrade the technology, and everybody should get used to this. The whole idea of doing a talk like this is that you must get conversant with the technology, because this is going to stay. Mr. Verma, this will stay for the rest of our lives. That you will see the trials are being conducted on video conferencing, though it will be very difficult according to me. But you never know, tomorrow there will be virtual courts for everything. So we must sit down, we must learn, we must upgrade our system and get conversant with the technology. Thank you so much for giving me the opportunity, and I really enjoyed interacting with everyone.
Thank you, everyone. And I think the same thing, we will be trying to do another session with another senior counsel on criminal defense aspect. Perhaps coming week, I will share with you the links. And again, I'm thankful to Mr. Pahwa for coming today and enlightening all these. Thank you.
Thank you. Thank you.